Good evening. How's everybody doing? Great to be learning with you on a Sunday, Yom Rishon. Let's light up the darkness. Who's in the house on a Sunday? Yehud in South Carolina, Stephen in New Hampshire, Melissa in Great Neck, Bill in Mid-Missouri, Joe in the Inland Empire, Guy in Ohio, Lucy in Minnesota, Shandora in the Bronx, Bella in Florida, Gail in Kansas City, John in Maine, Chaim in Florida, Ella in Southern California, Aoife in Florida, Alan in New York City. Welcome, everybody. So I was a few minutes late. We just got back from Poway, California, where Guns N' Moses screened. It was very emotional at the Poway Chabad Synagogue, where the shooting happened, the terrible shooting in 2019 that was inspiration for the movie. I think it was a healing event. A lot of people came, a lot of people stayed after. We had a long Q&A. It was special. It was special. So thank you for forgiving me. We did get back a few minutes late. We would have made it on time, but as we got close to LA, you might hear LA is in the news. There's all kinds of demonstrations, and that very much affected traffic near downtown LA, which we needed to skirt as we were coming back from the San Diego area. Okay, we are continuing our discussion of Mishna number 2 here in chapter 4 of Tractate Shevuos, the 26th volume of the Talmud. Our daf is page 32. We got a good start on 32a yesterday. So I think we're 3/4 of the way down 32a. And we pick it up. The Mishnah, our Mishnah number 2 here in chapter 4, taught, if they denied knowledge one after the other. Okay, so here we're talking about oath of testimony. Somebody has a litigation, a case before a beis din, a rabbinic court, and needs witnesses in order to prove his case so that he can, for example, get paid back from a borrower who is not paying back. So he has witnesses. Now the witnesses say, "What are you talking about? We didn't see you lend money to him." And he says, "Well, what are you talking about? I know you were there. How could you say you weren't there? Swear an oath before God that you weren't there." Right, so that's, or that you have nothing to say, that you have no information to give as testimony that will help me recover my money, right? That I will get a monetary judgment against the defendant in my litigation. The witness says, "We don't know anything." So I say, I know that you know. So swear, right? Take an oath that you have no information. And as we saw, if they take oaths outside of court, it will not trigger liability. If they take an oath in court, it will trigger liability. And then retroactively, the oaths made outside of court that they don't know anything will then become false oaths of testimony if they're supported by the oath given in court. If they give multiple oaths in court, only the first one would they be liable for if it turns out that they're lying, etc. Okay, so the Mishnah taught, if they denied knowledge one after the other, right? This is important because you need 2 witnesses to establish a matter. So if 2 of them take this oath of testimony that we don't know anything, it turns out that they're lying, well, the first one, as soon as he said he knows nothing, then the second one was meaningless, because once the first one says, I have no testimony to give, the fact that there's one other witness is meaningless, since you need 2, and one has already sworn in court that he doesn't know anything. So if he is lying, he's going to be liable. But the second one, even if the second one swears falsely, is not going to be liable, because after the first one has given that oath, the second one, it doesn't matter what they say, it cannot create a judgment, a monetary judgment, since it would only be a single witness. right? So if they denied knowledge one after the other, the first one who denied knowledge is liable, and the second one is exempt. As once the first witness denies knowledge of the incident, the second is an individual witness whose testimony is not decisive, and he is exempt from the oath of testimony. The Gemara notes the Mishnah is not in accordance with the opinion of this Tana, as it is taught in a Baraisa in the case of one who administers an oath to one witness, right? So one way is just to swear, another is to be adjured to swear, right? So if I say to you, hey, come testify for me, and then you just freely swear an oath that you don't know anything, you have no testimony to give, that's you swearing on your own. If I say to you, swear, that you have no information, and you say amen, that means I am adjuring you, or I am administering the oath to you. Right, so the Mishnah, so in that Baraisa it says, in the case of one who administers an oath to a single witness, the witness is exempt from bringing an offering for taking a false oath of testimony, because a single witness can't establish the matter. And Rabbi Elazar, the son of Rabbi Shimon, deems the witness liable to bring an offering. In his opinion, the second witness in the case in the Mishnah would be liable, not exempt, because after all, even if the matter can't be established and create a monetary obligation in court by the testimony of a single witness, he nevertheless lied and said he didn't have testimony to give when in fact he did. And perhaps if he hadn't done that, then some other witness would come forward and join him. The Gemara suggests, let us say that they disagree about this. One sage, the first Tana, holds when one witness comes to testify, it is to render the one against whom he is testifying liable to take an oath. And that is the reason that he is coming, as one witness cannot render him liable to make a monetary payment. And the other sage, Rabbi Elazar, the son of Rabbi Shimon, holds when one witness comes to testify, it is to render the one against whom he is testifying liable to make a monetary payment, and that is the reason he is coming. The Tanaim disagree whether denial by one witness constitutes a denial with regard to monetary matters or to making somebody swear an oath. What would that mean? Well, if he's going to swear an oath, if you cannot establish the matter by witnesses, right, but the plaintiff is saying, I have property in the possession of the defendant, right, and it's one of those situations where the defendant can be forced to swear an oath that he doesn't have that in his property, well, then perhaps a single witness gets him to swear that oath, or the lack of two witnesses. In other words, sometimes instead of creating a situation where money's going to change hands, instead what's being created is a situation where the defendant will swear an oath. And that seems to be what they're disagreeing about. Are they going to create liability to pay money, or are they going to create a situation where the defendant swears an oath? The Gemara rejects this analysis. And how can you understand their dispute in that way? Doesn't Abaye say, all concede with regard to a witness in the case of a sotah, the suspected adulteress, that he is liable for taking a false oath of testimony, and all concede with regard to witnesses in the case of a sotah, and there is a dispute with regard to witnesses in the case of a sotah. Now, this is not spelled out in the written Torah, but it is spelled out in tractate sotah. Right? In the Torah, we just had this in last week's Torah portion, what do we find? That the husband becomes jealous because the wife was secluded with someone who's not her husband, and it's a situation where she might have cheated on him and she might not. It's unknowable, but it's close enough, and then so that by rabbinic law, they spell it out. What does it mean? That the husband had cause to be jealous, right? He heard or he saw that she had secluded herself with some other man, and then he warns her. And the husband says to the wife, do not seclude yourself with that man. Now that warning has to be in front of witnesses. Then witnesses, either the same pair or another pair, see her actually seclude herself with that man that she was warned about. And then they say it to the husband, and the husband says to her, that's it. right? Now I'm telling you, either drink the bitter waters or get divorced, right? So at that point, based on the testimony of the initial warning and the testimony about the seclusion after warning, then we create the situation where she's going to go down to Jerusalem. This is only when the temple is standing, or up to Jerusalem, and she'll go through the ritual of the sotah. But what's important about it in this case is that, number one, there's going to be witnesses testifying to different stages of that process, and then she will have to swear an oath, which is actually administered to her. The priest says, were you secluded with that man? Or if you actually committed adultery, then these waters are going to kill you. And she says, Amen, Amen, essentially swearing an oath that she didn't commit adultery. Okay, let's get back to it. Right, all concede with regard to witnesses in the case of the sotah, and there is a dispute with regard to witnesses in the case of a sotah. All concede with regard to one witness, that he is not liable for taking a false oath of testimony because he cannot render another liable to make a monetary payment. Single witness can't establish liability to pay money. And all concede with regard to a witness testifying on behalf of the claimant when his counterpart, the defendant, is suspect about the oath. We'll get more into that. The Gemara suggests, rather, all concede that when one witness comes to testify, it is to render the one against whom he is testifying liable to take an oath. And that is the reason that he is coming. So, given the totality of the circumstances, a single witness can not cause the judges to say to the defendant, you have to pay money, but the testimony of a single witness would be enough to create a situation where the defendant will have to take an oath in order to say, hey, the property that the plaintiff claims is in my possession is not in my possession. He swears that oath, and then he doesn't have to pay. But forcing him to swear that oath, that can be done by the testimony of a single witness. So there are some situations where we accept the testimony of a single witness to do what? To make someone swear an oath, or another situation, which we've seen for the single witness, is a woman who is told by a single witness that her husband died overseas, right? So lest she become an aguna, a stranded wife who can never remarry, because there were not two witnesses who saw that her husband died, by the testimony of a single witness, she can go ahead and remarry. Although if it turns out that the single witness lied or they made a mistake, it's going to be pretty severe consequences for her, but that's a risk she's willing to take in order to get on with her life. Okay, so let's keep going here. The Gemara suggests, rather, all concede that when one witness comes to testify, it is to render the one against whom he is testifying liable to take an oath, and that is the reason he is coming. And here they disagree about this. One sage, Rabbi Elazar, the son of Rabbi Shimon, holds a matter that causes financial loss is considered to have monetary value. Although the testimony of one witness does not render one liable to make a monetary payment, occasionally the party against whom he testified will prefer to pay rather than take that oath that property of the plaintiff is not in his possession. And rather than take an oath, right, where he's afraid maybe I'll make a mistake, he's sure he doesn't have the property, but what if he's wrong? He'd rather not take an oath, and so he'll just pay, right? And so in that situation, the testimony of the single witness, even though there could not have been a judgment against the defendant forcing him to pay, the fact that the testimony of a single witness at least raises the liability of the defendant to the level of having to swear an oath in order to not pay. Since he'd rather not swear an oath, he just pays. And so therefore, indirectly, the testimony of a single witness forces him to pay. In those cases, the testimony of one witness does in fact cause money to be paid. And one sage, meaning the first Tan in this situation, holds a matter that causes financial loss is not considered to have monetary value in the sense that it wasn't testimony that led to a judgment. Since testimony that creates a judgment has to be by the mouth of two witnesses. Now, with regard to the matter itself, Abaye says, all concede with regard to a witness in the case of a sotah that he is liable for taking a false oath of testimony, and all concede with regard to witnesses, right? So a single witness versus two or more, all concede with regard to witnesses in the case of a sotah, and there is a dispute with regard to witnesses in the case of a sotah, right? So these are kind of general introductory statements that with respect to one matter in the case of the sotah, all agree about a single witness. With respect to a different matter, all agree about two witnesses. And with respect to a third matter, there is a dispute. So what's going on? All concede with regard to one witness, and all concede with regard to a witness testifying on behalf of the claimant when his counterpart is suspect about the oath. What's going on? The Gemara explains. All concede with regard to a witness in the case of a sotah, single witness in the case of the suspected adulteress, that he is liable for taking a false oath of testimony in the case of a witness of impurity, of tumo. What does that mean? This is referring to a case where the husband issues a warning to his wife in the presence of two witnesses that she may not seclude herself with a certain man. And two witnesses come and testify that she secluded herself with that man. And then one witness comes and testifies that she actually engaged in intercourse with that man. Now, if two witnesses had seen the wife have relations, physical relations, with another man, not her husband, then she would not be a sotah. She would be an adulteress, right? She would not be a suspected adulteress. She would be a proven adulteress by the testimony of two witnesses. But here we have two witnesses to the warning, two witnesses to the seclusion, and only a single witness to the physical act between the wife and this other man. So what does the single witness add in that situation? We haven't established her as an adulteress. Why is he going to be testifying at all? What's going on here? One witness testifies that she engaged in intercourse with that man. As in that case, the merciful one accorded credibility to the witness, as it is written with regard to a sotah, and there is no witness against her that she engaged in intercourse. From that verse, it is derived that any witness that there is against her is sufficient to render her forbidden to her husband and enable him to divorce her without paying the ketubah, the sum mentioned in the marriage contract. Now that's only because there were two witnesses to the warning and there were two witnesses to the seclusion, and then there was a single witness to the sexual act itself. In that situation, the husband can divorce her without paying the ketubah. Therefore, that single witness who testified that she engaged in intercourse with that man is, for all intents and purposes, a witness to a monetary matter, since the husband can divorce her without paying the ketubah payment. And all concede with regard to witnesses in the case of a sotah that each witness is exempt from liability due to a false oath of testimony. Now, this is referring to the case where, here we're talking about the witnesses of warning, the witnesses who saw the husband warn the wife, don't seclude yourself with that man. They testify that the jealous husband warned his wife not to seclude herself with a certain man, as each witness is the cause of financial loss, not a direct cause of that loss. In other words, because all they witnessed, right, this pair of witnesses will only in the end testify about the warning. So by themselves, right, if all they came to court to testify was that the husband warned her, okay, and then they established that she was warned, there's no proof here that she actually secluded herself with that man. All they saw was the warning. So their testimony by itself cannot cause financial loss. It would just be one step on the way to a financial loss, in this case, a financial loss for her, where she could be divorced without a ketubah. But their testimony by itself can't cause financial loss. Now we're on page 32b. And there is a dispute with regard to witnesses in the case of a sotah, where we have two witnesses and there is a dispute. What is that? This is referring to witnesses of seclusion, right? So somebody witnessed the warning. Now we have two witnesses to the seclusion, okay? Now, are these going to be liable if they swear falsely to liability for swearing a false oath of testimony? In order for them to be liable, their testimony would have to lead to a financial loss. So, doesn't it? Right? Doesn't it? If they witness that she secluded herself, that's going to be enough to establish her as a sotah. And then if they, if she chooses to not drink the bitter waters, then the husband can divorce her without paying the ketubah. So it sounds like their testimony would trigger a financial loss for her. And if they swear falsely, they should be liable for swearing a false oath of testimony. So what's going on? Let's see. Why is this a dispute? One sage, Rabbi Elazar, the son of Rabbi Shimon, holds that a matter that causes financial loss is considered to have monetary value, and each witness is liable for taking a false oath of testimony, as had they testified, the woman would lose her marriage contract. But the other sage, meaning the rabbis, the majority who overrule Rabbi Elazar, they hold that a matter that causes financial loss is not considered to have monetary value, and he is exempt, right? Because again, it's not like a case where they come and testify that Reuven lent Shimon money, and therefore Shimon has to pay back the money. It's still, what they saw was that she secluded herself. That may or may not lead to loss later. It's still, the connection is a little bit attenuated, and so we can't say that the testimony causes direct financial loss, and that's why if they swear falsely, they would be exempt. New subject. It is stated above further, all concede with regard to a witness testifying on behalf of the claimant when his counterpart is suspect about the oath. All concede in the case of one witness, as in the incident of Rabbi Abba. And what are these cases all about? The Gemara explains. All concede with regard to a witness testifying on behalf of the claimant when his counterpart is suspect about the oath. Right? So if a witness is going to come and say Reuven did lend Shimon the money, and it's only one witness, so this might lead Reuven to adjure Shimon to swear an oath that he's not holding Reuven's money. But if we have reason to believe that Shimon is a liar and that he would swear a false oath, even if it's not true, and we have reason to suspect that, that might change the consequences for the witness who's going to come and swear about the loan from Reuven to Shimon. The testimony of one witness renders the borrower liable to take an oath that he does not owe money. And the Gemara asks, in a case where who is suspect? Who are we talking about as suspect? If we say that the borrower who is denying the debt is suspect, and it is a case where the lender says to the witness, if you came and testified on my behalf, I would have taken an oath and taken the sum owed me from the borrower. Since he is suspect with regard to oaths, why would the witness be liable for taking a false oath of testimony? Let the witness say to the lender, who could say that you would have taken an oath? Since there is no certainty that he would have taken the oath, the witness is merely the cause of a financial loss, not a direct cause. Rather, it is a case where both the borrower and the lender are suspect. As the master says, since both the borrower and lender are suspect that they are people who might take a false oath, the oath reverts to the one who initially is obligated to take it, i.e. the borrower, and since he is unable to take the oath because he is suspect, he pays the entire claim to the lender. Right, so we saw this shifting of oaths. If we say that a lender adjures a borrower to take the oath because he is holding my money, but the borrower is suspect, somebody who might take a false oath, in that situation, the judges would step in and say, well, the fact that he's going to swear an oath is meaningless because he would swear and it might not be true. So we're going to shift the oath burden to the lender, because that's a trustworthy person. So if you are willing to take an oath that you lent to this guy, he's going to have to pay. But if both of them are suspect in this way, then their oaths don't work. and the fact that we're in court is going to be enough to trigger a judgment. That's what we're learning here. Rather, in a case where both the borrower and lender are suspect, as the master says, since both are suspect, the oath reverts to the one who's initially obligated to take it, which is the borrower. And since he is unable to take the oath because he is suspect of a person who would lie, so he has to pay the entire claim to the lender. One witness rendered the borrower liable to pay the debt. Abaye said, all concede, right? And we got to the oath the idea of anyone taking an oath because there was at least one witness. Abaye said, all concede in the case of one witness, as in the incident with Rabbi Abba. What was this incident? There was a certain man who snatched a silver ingot from another. Sounds like a thief. He just grabbed it and took it. He snatched a silver ingot from another, and the one from whom it was taken came before Rabbi Ami, while Rabbi Abba was sitting before him. And he went and brought one witness who testified that the defendant indeed snatched the silver ingot from the plaintiff. So the one who snatched it said to him, yes, it is true that I snatched it, but I merely snatched that which was mine. I was not stealing. I was taking back what was already mine. Rabbi Ami said, how shall judges rule in this case? Let the judges require him to pay. But there are not two witnesses who witnessed the robbery. Let the judges rule to exempt him from payment. But there is one witness that he did snatch the ingot. Based on the testimony of that witness, let the alleged robber take an oath that he did not snatch the ingot. But once he said, yes, I snatched it, but I merely snatched that which is mine, his legal status, his halakhic status, is like that of a robber who is disqualified from taking an oath because he admits that he snatched. Rabbi Abba said to him, he is one who is obligated to take an oath but is unable to take an oath, and anyone who is obligated to take an oath but is unable because he has the status of a robber is liable to pay. So in that case, were that witness to take a false oath and deny knowledge of the matter, he would be liable because if he had the correct information and testified, he could trigger, right, this financial obligation through the mechanism that we just discussed. Therefore, if he's lying, even though he's a single witness, he is liable for a false oath of testimony. New subject. Rav Papa says, all concede with regard to the witness of a death that he is liable for taking an oath of testimony. If he took a false oath and then denied knowledge of the incident, and all concede with regard to the witness of a death that he is exempt in that case. So why would the witness of a death have an oath? Why would an oath be needed for the witness of a death? Well, because it might allow a woman to get remarried, and it might allow an heir to inherit, right? So these are very important matters. Let's keep going. The Gemara elaborates. All concede with regard to the witness of a death that he is exempt where he said to the wife herself, right, the widow, that her husband is dead, but he did not tell it to the court. And now he denies his earlier statement. As we learned in a Mishna, Eduyos 1:12, the woman who said, my husband died, shall remarry on the basis of her own testimony. Likewise, if she says, my husband died, she shall enter into yibum with her brother-in-law on the basis of her own testimony. The fact that the witness subsequently denied knowledge of the matter does not cause her to lose the marriage contract, since she can come to the court and testify based on the statement of the witness to collect her marriage contract. All concede with regard to the witness of a death that he is liable in a case where he did not say that the husband is dead to the wife herself, nor did he say it to the court. In that case, his denial of knowledge in the matter causes the wife to lose payment of her marriage contract, right? If he's the only one who knows that the husband died and he refuses to testify about it, or denies knowledge and swears that he has no knowledge when in fact he did, then he causes her, right, to lose the ability to remarry and to collect the ketubah, which is a financial loss. And that's why, since we're saying a matter has to trigger financial loss for the one who swears a false oath of testimony to be liable, there is financial loss in that situation. The Gemara asks, shall we conclude from here that according to Rav Papa, in the case of one who administers an oath to witnesses with regard to land, right, somebody who adjures witnesses in a land case, that the witnesses are liable for taking a false oath of testimony, given that the marriage contract here is collected from land belonging to the husband? Well, this matter is subject to a dispute between the sages on page 37b. And the Gemara answers, no proof may be cited from here, as perhaps Rav Papa is referring to a case where she seizes her husband's movable property as payment for her marriage contract. Therefore, this is not considered testimony with regard to land. New subject. The Mishna teaches if one of two witnesses denied knowledge of the incident, and the other one admitted that he had knowledge and he proceeded to testify, the one who denies knowledge of the incident is liable, right? Because he takes it from two witnesses that could create a judgment down to one witness, which could shift the burden and create an oath situation, but is obviously much lower level of establishing a matter than two witnesses. So if there was one witness ready to testify, and then another one falsely swore that he didn't have information to give, then he is liable and he should be liable. Makes perfect sense. And the Gemara asks, why was it necessary to teach this law in the Mishnah now that in the previous case where the potential witnesses both denied knowledge of the matter, one after the other, and you said that the first is liable and the second is exempt? In the case where one denied knowledge and one admitted that he had the knowledge and proceeded to testify, is it necessary to mention that the one who denied knowledge is liable? Haven't we already established that clearly? And the Gemara answers, no. It is necessary to state this law in a case where both of them denied knowledge of the matter, and then one of them retracted his denial and admitted to knowledge of the matter within the time required for speaking a short phrase. And this teaches us that the halakhic status of a pause or retraction within the time required for speaking a short phrase is like that of continuous speech. And the Gemara asks, well, granted, according to Rav Chisda, who interprets the previous case in the Mishnah, in which the two witnesses denied knowledge of the incident as one, and they are liable in accordance with the opinion of Rabbi Yosef HaGalili, a different law may be learned from each clause in the Mishnah. It is learned from the first clause that it is possible for two events to coincide precisely, and the latter clause was necessary to teach us that the halakhic status of a pause or retraction within the time required for speaking a short phrase is like that of continuous speech. The guy says, I have no information to give, but you know what? No, I do. I'm going to admit it. I have information to give. So the fact that he said no just gets erased because he didn't, pause long enough to break it up into two statements. But if there was a long enough pause, then he swore in court that he has no information to give. And that's it. He can't retract afterwards. He can't come back to court the next day. He can't come back to court the next hour. He can't come back to court 10 minutes later. Only if there was no break can he retract. Otherwise, it's a complete statement. Now, the judges may have reason to suspect that this guy lied, but absent that, once testimony is given, it's given. Now, within the time required for speaking a short phrase is learned from the first clause, and the law of within the time required for speaking a short phrase is learned in the latter clause. Why do I need two clauses to teach the same law? And the Gemara answers, even according to Rabbi Yochanan, both clauses are necessary, lest you say that this statement, the legal status of a pause or a retraction within the time required for speaking a short phrase is like that of continuous speech. Maybe that applies only in a case where the first statement is a denial and the second statement is a denial. But in a case where the first statement is a denial and the second statement is an admission, perhaps no. Then this legal status is not like that of continuous speech, and one cannot admit knowledge after having denied it. Therefore, the Tana teaches us that even in a case where he retracts the denial and admits that he has testimony to offer, its halakhic status is not like that of continuous speech. I'm almost done. Questions or comments, please get them in now. The Mishnah teaches, if there were two sets of witnesses that took the oath of testimony, and the first set denied knowledge of the matter, and thereafter the second set denied knowledge of the matter, both sets of witnesses are liable if they're lying. And why does the second set still have liability even after the first set it said that they have nothing to offer? Because they're two pairs of witnesses. Either pair could establish the matter in the court case. Now the Gemara asks, granted, the second set will be held liable, as since the first pair of witnesses denied knowledge of the matter, the ability of the plaintiff to collect his monetary claim now becomes dependent exclusively on the second pair, and their denial caused his loss. But in that case, why is the first set liable? When they claim they have no knowledge, there was still another pair of witnesses. So their false oath of testimony did not trigger a monetary loss to the plaintiff, since there were still other witnesses that could be relied on. So why do we say that they are liable? And Ravina said, and now we're at the top of page 33a, what are we dealing with here? We are dealing with a case where the two witnesses in the second set were relatives through their wives at the time of the denial of the first set of witnesses. The two witnesses in the second pair were married to two sisters, and brothers-in-law are unfit to serve as witnesses together. Therefore, the claim of the plaintiff is entirely dependent upon the testimony of the first set of witnesses. And the sisters, who were the wives of the witnesses in the second set, were moribund. Unless you say that since presumably the majority of individuals who are moribund will actually die very soon, right, on their deathbed, and therefore these two witnesses are fit to testify together. Therefore, the Tana teaches us that since now, in any event, the wives have not yet died, their husbands remain unfit to testify together. This is one of those extreme hypotheticals just to test understanding of the law. Obviously, that's really unlikely to ever happen in the real world, but it's an important principle where you're establishing that the testimony of the two sets of witnesses is just on the edge of being necessary, but not quite there. Okay, that's what I've got for us today. See one question from Sharon. Remember that a woman needs only one witness for a woman to determine that her husband has died and she is able to remarry. So under that circumstance, would the second witness testimony still be relevant? Yes. Well, you're saying that the first witness is enough for her to remarry, but with those consequences. Whereas if a second witness comes and says, yes, the two of us saw your husband dead, then she's free to remarry. And even if both of them made a mistake and the husband shows up again, this woman is not going to have to divorce the second husband because the first husband is legally dead. She's not going to face this, and the children that she would have by that second husband would not become mamzers, which would be the case if she remarried on the testimony of a single witness. So that's a huge difference, whether she's relying on two witnesses or one to establish that her first husband had died. Very good point. That's what I've got for us today, and with God's help, we'll be together again tomorrow, Monday, at the regular Monday time, 6 p.m. Pacific. Have a great night.